Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I will be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As you can still see on the screen, I'm a lawyer at Samfiru Tumarkin, LLP, which is Canada's leading employee-side employment law firm. Housekeeping items. If you want to get a hold of us, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And as I always encourage you to do during these broadcasts, please send in your questions right away. I very much try to get to all of the questions. I don't want to leave any questions unanswered. And the faster you get your questions in, the more likely I will be able to get through them all. Okay, great. Let's get started. Got a couple questions coming in, but if you have a question, please send it in. Question from Coco. My company recently outsourced their human resources and are now under their guidance asking us to sign contract amendments. There are clauses that allow them to change our roles and duties. Should we be concerned about this? I'm going to answer your question indirectly. Anytime your employer asks you to sign a new contract, you should always be concerned about what's in the contract. And most of the time, if not all of the time, I mean, it's a cost benefit, but you're going to want to get legal advice on what those changes are. Okay. And so generally speaking, not always, but generally, well, I'll back up a second. So an employment contract is not for your benefit primarily. It's not for the employee's benefit. It's for the employer's benefit. What a written employment contract is an employer will say exploiting its superior bargaining power over the employee at the time of contract formation, usually when you start your job, but it could be later on as well, by getting the employee to sign a document which binds the employee's rights and limits the employee's rights as against the employer. The primary means by which it does that is it limits in those contracts an employee's rights upon termination. And these limits can be stark. It can take, and dramatic, it can take an employee's rights upon termination from 24 months down to 8 weeks. So less than 2 months. So you got to get legal advice. Like if you have 24 months coming to you and then you sign a contract and now you have only 8 weeks coming to you upon termination, that's a massive loss of your legal position or your potential legal position, and you need to know about that before you sign it. Now, when you are in an existing relationship with an employer, and then the employer asks you to sign new contracts or contract amendments or what have you, you can choose to sign it or not to sign it. But if you don't sign it, you have to understand that the employer may terminate the employer really has 3 options. It can continue on as usual. It can, 2 options, or it can terminate your employment. And so, or it can, if there are changes connected with why there's a contract, like so if there's a promotion or demotion or something like that, they can, or salary change, they can impose the changes upon you. It's the 3rd option. But generally speaking, if you refuse to sign a contract, you have to be prepared for the possibility that the employer could terminate you, could fire you. Okay, so, if you've been with your employer for 1 year, you probably don't necessarily want to do that. But if you've been with your employer for 25 years, maybe you shouldn't sign the contract because you might end up signing away a substantial amount of severance. But you have to be prepared for the fact that if the employer fires you, you are now pursuing that severance. So just generally, if your employer is asking you to sign a new contract, you certainly should be concerned. Now, to your specific question, there are clauses that allow them to change our roles and duties. Should we be concerned about this? Well, I haven't seen the specific clauses, but I'm guessing what they are clauses that permit the employer, when an employer, or if an employer changes that employer changes your position in the future, you've agreed that those changes aren't a constructive dismissal of your employment. Okay, and so simply, it provides more protection for the employer if they change I'll back up here a second. So we talked about if you're terminated without cause, and you're terminated that day, you're entitled to severance, which is money in exchange for your termination. Okay? That money can be quite lucrative. It can be as much as 24 months, depending upon what your contract says, your age, length of service, and position. Okay, so, but that entitlement to severance flows from your termination without cause. However, there are certain situations where the actions of the employer are the same as a termination. They are a de facto termination, and most of you have probably heard of that. It's called a constructive dismissal. So there's the real classic way to get to a constructive dismissal is where your employer breaches a fundamental term of your employment contract. So usually pay cut, hours cut, resulting in a loss of pay, or a demotion, something like that, change of position. The key to all of them is that the change has to be non-trivial. It has to be a fundamental change. So if your take-home pay is reduced by 3%, that's not going to get you there. But if it's reduced by 21%, it probably will. Or if it's a 10% reduction and a demotion, it probably will. If it's just a demotion, it would have to be a substantial, a significant change. So that if there's a change in your position, one of the things that employers do is they have contracts that say, or contractual terms that say in your employment contract that such a change is not a constructive dismissal. So that might be what it is. Or it could be there's a doctrine in employment law where if there's a substantial change between the contract the position that you were under and the contract that you signed. So let's just say you started off in the mail room, you signed a contract at that time, an employment contract, and it contained an enforceable termination clause limiting you to the 8 weeks of severance I talked to you about, or statutory severance. And then you sign no more new contracts, but down the road you become the CFO, let's say. Well, there's a doctrine in law that says that the mailroom contract doesn't apply to you as a termination, and therefore doesn't limit your termination entitlements, because the difference between your position when you signed the contract and when you ended up with was too stark. It was too large, we'll say, fundamental change in role and duties, and so. But there could be language in contracts that say, regardless of your change in duties, this termination clause travels with you. So it might be one of those two. And either one of them serves to limit your rights. So you want to know what those are about. And you may wish to talk to an employment lawyer about that. I would, depending on your situation, but it's probably worth it to talk to an employment lawyer to find out what the impact on your rights is from the specific changes in your contract. If you need to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay. Question from Jimmy. Can an employer fire you for raising a health and safety concern? No, under the law in any province, under your occupational health and safety legislation. But when they do, your remedy is a penalty. There's no mechanism in law that can stop an employer from terminating you, but there's deterrence mechanisms and consequences for employers when they do that. So if they fire you for a health and safety issue, and I can't speak for every jurisdiction, I'll just talk about in British Columbia. So in British Columbia, but it's very similar across all the provinces. So in British Columbia, if you report a health and safety issue, you cannot be fired. I should rephrase that. There are consequences to the employer under the workers' compensation regime in BC called WorkSafe BC. And if you're fired as a result of reporting a health and safety issue, you have access to what's called a prohibited action complaint. Prohibited action complaint has two remedies. One is reinstatement, I believe, and the other is back pay from the date of termination to the date of hearing, which could be 13 or it could be 12, 13, 14, 15, 16 months, something like that. So it can also be quite lucrative. And your second part of your question, if you're still on probation when you raise these issues, I don't think that matters as far as the health and safety regime is concerned, right? So and that may be different in each province. And it could be wrong even in BC. I've never encountered that particular issue, but I don't think it is. If WorkSafe BC and occupational health and legislation, occupational health and safety legislation in each province and territory is trying to keep workers reasonably safe. And so I can't see that the safety mechanisms in place and policy considerations within the applicable legislation not applying just because you're on a probation period. But I'm open to being incorrect about that. So no, I think it would still apply to you, but I'd find that out before taking any action because I don't know the answer to it. But if they were to fire you after you reported it, you'd certainly have access to those remedies, but it doesn't mean you're going to work there anymore. And reinstatement would be unlikely after a few months of employment, as opposed to if you were a 20-year employee in that situation. Yeah, I think that answers your question completely, Jimmy. If I didn't answer it completely, let me know, and I'll see if I can circle back around to it. Oh, thank you. Dennis had some complimentary words to say about our session today. Thank you, Dennis. I can't identify this person, so I won't. I can't even go by the initials. Okay, so my boss is trying to fire me while I'm on short-term disability. I had my leave extended, and my doctor and now my manager wants to get rid of me. I ended up seeing a document where he is trying to build a case and make it seem like it is for reasons that aren't related to my leave. What can I do? Well, nothing has happened, right? Like, so you're on medical leave. It's not. So I just want to unconflate two concepts here. When you are medically unable to work, and your doctor says, confirms that with medical documentation, medical note, you're on a medical leave. How you get paid while you're on a medical leave is potentially short-term and long-term disability. Okay, so you're not on, yes, you're on disability, but the thing that you're on is on medical leave that prevents you from working, and you're being paid usually through the insurance company because you're on properly recorded disability. And so your employer is trying to get rid of you while you're on disability. I certainly would save that document that seems to implicate your employer. If your employer fires you, so again, there's no mechanism anywhere in law that stops an employer from firing an employee at any time for any reason. Okay? But there are penalties and consequences if they do so in violation of the law. Okay, and so while you are medically unable to work, you'll have what's considered a disability under the appropriate human rights legislation in your jurisdiction. Okay, and so all of the human rights legislation in every jurisdiction in Canada, including the federal jurisdiction, share the same characteristic that you can't be terminated or discriminated against because of a human rights protected ground. So if you are disabled from working because of your medical issue at the moment, your employer can't fire you for that. And if it does, you have a remedy through the human rights legislation. And so I think there's great variance in terms of value in each jurisdiction. I'll say in BC, your remedies for being fired due to discrimination on the basis of disability, your remedies are lost wages, which is the same as severance, and injury to dignity, which is it's hard to define. It's really you've suffered an indignity as a result of being terminated because of a human rights protected ground, and you get a certain amount of money as a result from that. There's no real proper way to evaluate what that's worth. They tend to be small, but the damages for that tend to be small, but they're getting bigger. And it's really an evaluation of your level of vulnerability coming in to the discriminatory act, the egregiousness of the act itself, and the impact on you. And so, for example, if you were to, after being terminated as a result of your disability, you because you were pre-vulnerable because of an existing mental health condition, and then you spiraled into a depression and weren't able to work for 2 years, the tribunal would really consider that in its in its award of damages. And sometimes damages can actually be quite large, but there's a great deal of uncertainty as to how much injury to dignity actually is worth. And all I can really tell you is that it is based on those three factors. A number comes out and it's increasing over time. However, I will say there are more practical concerns if this does occur to you, because if that's your only realm of redress, the human rights realm, different jurisdictions have different structures of human rights and therefore different availability. So, for example, in BC, the Human Rights Tribunal has exclusive jurisdiction to anything, any discrimination arising under the or pursuant to the Human Rights Code, BC Human Rights Code. But because of that, the Human Rights Tribunal is quite delayed in hearing matters, and matters can take several years to get before an adjudicative panel. So you have to consider that as well in terms of how you approach next steps if you are in fact terminated. But as of right now, I mean, you're on medical leave, you're trying to get better. I don't think there's anything you can do other than save all the documents you can. You can't, if your employer is going to fire you because you're on disability, or sorry, because you're on medical leave, like there's nothing you can do to stop that. Well, I shouldn't. You may be able to hire a lawyer to write a sort of an ominous letter threatening them with consequences if they do. But if you get a lawyer to write you a letter while you're still to your employer while you're still employed, I can't see that relationship going well over the medium term. So, for now, I don't think there's much you can do other than make sure your medical leave is properly papered, save all your medical documentation, and if you save that document you obtained from your employer, and any other documentation that will help you prove that there's some sort of conspiracy on the part of your employer to get rid of you. But I would also consider getting legal advice. I've given the information already. I'll give more of it at the end. The moderator may put the information on the screen periodically as we go. But certainly, if you want to talk to us, we can look at your matter. Jimmy's back. I was fired from a very big company of transportation within 2 weeks of hiring. The reason is raised to see health and safety question. I told them I cannot work 16 hours a night shift. It was very dangerous for me and the people on the road, and I have all the evidence that I have emailed the employer, requested accommodation, but they gave me termination. Yeah, Jimmy, I think you need to file an occupational health and safety. Oh, are you in BC? Wondering already, submitted the application for a prohibited action from WorkSafe BC. Wondering if the employee can do this by law. And another question is, if I win this case, what is the employee obligated to do? So yes, of course, it's designed for lay people, non-lawyers, to access the health and safety regime for this very reason. And the remedy, as I said, is you can get lost wages from the date of, so like severance, from the date of your termination to the date of hearing, which, less, I believe anyway, less any money you earn at a new job. So, it can be quite a bit of money. So I wish you good luck with that, certainly. But it sounds like you're already moving in the right direction with that. So I don't know if you specifically needed my impression of the situation. But please feel free to reach out if you need more. Martin asks, I was originally hired as an out-of-province remote worker, which is stated on my contract. My employer wants to change this to a 3-day office requirement, but that is not possible for me because you live out of province. Is it feasible that they are asking me to relocate and not offering me any compensation for this? Okay, so I think there are two parts to this, Martin. There's a life question. Do you want to do this? If I was asked to relocate anywhere, I wouldn't be able to do it from a family and life perspective, and so it would just be a non-starter for me. So you need to decide that part, and if you are able to relocate and it's a great opportunity, maybe you do it. If it's not, maybe you don't. But the question is, The question you're really asking is, first of all, number one, can we stop them from imposing this upon you? No. Number two, if you don't do it, what happens? So if you just say, I'm not showing up for work, I can't, I'm located in a province, what are they going to do at that point? Are they just going to have you keep working, or are they going to fire you? And then if they fire you, what are your remedies? So you need to know what's in your employment contract. Another way of looking at this is it a constructive dismissal? And most of the time, if there's a relocation outside of an hour's drive kind of thing, 1 to 2 hour drive, probably is going to be a constructive dismissal, unless it's contemplated when you were hired that this might be something that would occur, or a relocation might be something that would occur, or if the moving to a remote situation is reasonable in the circumstances potentially. But if you were hired as an out of province worker to work remotely, I don't see it not being a constructive dismissal if it were to come to that. But I think the most likely play here for you is, number one, you need to get legal advice on your legal position immediately. If you have a few weeks of severance coming to you under contract and that's it, then probably, but you're not going to relocate under any circumstances, then probably what I would do is I'd have a frank discussion with my employer and just say, listen, I can't relocate, but I know the job. I can train the next person. Can you give me 16 weeks of runway where I'm working for you remotely, as I have been doing, giving me time to get my financial affairs in order and find a new job? And then maybe you can just basically have some sort of arrangement with your employer where you have working notice until the end of your employment, or for a certain amount of time, allowing you to find a new job. You find a new job, you move on. That might be something both parties are interested in, and that would help you. Move on. However, I would also, once you find out your answer to those big ticket items, I get legal advice on your contractual situation, how much severance you have coming to you. It may be that you might have a bunch of money coming to you, and the best play for you is just to not cooperate with their move at all, under legal advice. Okay, this is not something you should do on your own. It's too complicated. And then see if they terminate your employment, or constructively terminate your employment. Then you can pursue severance entitlement. But you can't do any of that without answering those big ticket items and getting legal advice. So 100% you need to speak to a lawyer before taking any next steps. And we'll put the information up on the screen shortly, and I'll read it out at the end as well. Okay, G asks, my employer has told me that I can resign instead of returning from medical leave. Medical leave. They said they will file as without cause, but I am not sure. Should I resign? No, you should never resign. It's due to a lot of workplace conflict. Sorry, one sec. A lot of workplace conflict. Admittedly, I'm worried about going back, and my doctor said it may not be the best options. Not be the best, but what options do I have? Okay, so I've been talking a lot about your entitlements upon termination, specifically money. I mean, it's a little more complicated than that, because you can be terminated on working notice and then you don't get money. You just get to work in your job for a period of time. But generally speaking, we've been talking about money in exchange for, or money upon termination. Okay. But that only occurs if you've been terminated without cause. Okay. If you quit, you get nothing. And if you're terminated for just cause, which is usually either progressive discipline, 3 written warnings and you're out, or, some egregious single conduct on your part, like fraud, theft, you punched your boss in the face, you came to work, drunk, although not always that one. Single major incidents can result in termination where you don't get any money, but you have to be but generally speaking, the vast majority of employees upon termination, if the termination is today, are entitled to severance. Okay. Termination takes effect today, they're entitled to severance. But not if you resign. And so if you resign, file without cause. I don't even know what that means. I think they're trying to trick you. They're trying to basically get you to resign, not have to pay you anything, and then they'll file an ROE that allows you to get EI. I think that's what they're telling you, because they're basically trying to pull a fast one on you potentially in order to save themselves money. But on the other hand, if you are unable to go back due to the situation, although again, they have to provide you with a non-toxic working environment, and if much of the conflict is not driven by you, they would be failing to do that, and that would be a constructive dismissal. So, I think you need to talk to an employment lawyer right away. I don't think you should take any action until you talk to an employment lawyer. Your matter is complicated, and we need to know, or you need to know, how much money you have in play in terms of severance, because to me, when I read what you're saying, your employer is trying to trick you so that that's what it seems like anyway. But I don't have all the context. But it seems like the employer is trying to trick you in order to save itself money that it would have to pay you in severance, and try to get you to think, well, okay, that's great. I will be eligible for EI, and that's where I get my money from. But you need to talk to a lawyer first to find out if you're missing out on a bunch of money. Okay, how much time do we have? Almost very little, and 3 questions. Okay. Question from HT. I work as a consultant, and my job requires me to use a personal vehicle to drive around and visit clients. 100 kilometers a day. Reimbursement, 20 cents less than CRA suggested rate. When I accepted the job, well, it's not clear it's a job. It might be a contractor position. I wasn't aware of all these additional costs. Using my personal vehicle for work was not a clause in my employment contract. What are my rights here? I don't, are you trying to get more reimbursement so if you fall under the Employment Standards Act, I think there's material in there about costs that your employer should be paying for you. I'm not very familiar with it because it's not part of my practice, but if you're provincially regulated, take a look at the employment standards legislation in your jurisdiction. I wouldn't be surprised if it's covered in there, but okay, if you bring an employment standard, if you are in fact an employee and not a contractor, if you are a pure independent contractor, then this is really something you should have negotiated at time of contract formation. But let's just say you're an employee and the Employment Standards Act applies to you. Saying that to your employer, or bringing an employment standards branch complaint, or whatever the body is called in your jurisdiction, isn't going to, it's probably going to do great harm to your relationship with your employer, and you probably won't have that job for very long. So I think here the solution is probably amicable. Have a conversation with your employer about real costs you're incurring, and see what solutions they can come up with. And if they're not prepared to meet you any of the way, maybe it's time to look for a different job. I don't know the situation. I don't know how much they're paying you, but if you're losing a lot of money to this, then you have to consider voting with your feet and, working in your existing job until you can find another job. So, but first things first, I think probably the right solution here for you is to have a conversation with your employer and see if they can meet you halfway or something. Okay, Betty's got the last question. Our company is being bought out, and we're meeting with another office. I've been here 10 years, but management is very tight-lipped about my position moving forward. I'm sorry to hear that. I've been through mergers and acquisitions before. It can be scary. If they let me go, can they use the old business closing to do this so they don't have to pay me anything? Is there something that I can do to prepare for the worst? No, there's nothing really you can do to prepare for the worst. But I don't know if the new business is acquiring your existing business or the old business by way of share purchase or asset purchase. If it's a share purchase, which is the most common, then your employment continues on as usual. And if they want to terminate you, they can only do so pursuant to whatever your employment contract says. And if your employment contract is silent on termination, pursuant to the law, the common law with respect, and I guess employment standards with respect to termination, and certainly that would be the best outcome if they terminate you. If it's an asset purchase, your employment is extinguished technically on the date of the acquisition. But if your employer has you continue to work with the new employer has you continue to work with them, doesn't draw attention to the fact that this is your first day or that your employment has been extinguished, then your previous length of service is grafted on. But if it makes you sign a new contract that limits your termination rights and says specifically your termination date is today, then you have a choice, an election as to whether or not you want to go after your old employer for your severance. But if you've got a new job lined up already with the new employer, it could be that your severance claim against the old employer is not worth anything because any money you would have made at the new employer is deducted. So it's complicated. I will say this: when something happens, Betty, because you can't do anything, they're going to do what they're going to do. When you have new news, you should talk to an employment lawyer right away. I'm going to put all over our firm's information on the screen because I have told a lot of you to talk to an employment lawyer. But if you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, we did it. We got to everyone's questions. Good questions today. Thank you for joining us. If you want, I believe we have another session on Monday. I think it's Monday. It's going to be on the screen in a second. And I believe it's with Chris Justice. I will be back in 2 weeks at the same time slot, 10:30 a.m. Pacific time. But in the meantime, we're going to have sessions next week. Oh, there it is. Okay, Monday, May 12th, 1:30 p.m. with Chris Justice, 1:30 p.m. Eastern time. Join us for that. Other than that, great questions today. Have a wonderful and safe weekend.